Hello, thank you for watching my video blog today. My name is Christy Morrison with Oliver Luxury Real Estate, and today I'm so excited to have our special guest today. His name is Michael Graham. He is a local attorney specializing in estate planning.
Thank you for having me today here, Christy, and hopefully this will be an informative session for your viewers.
Great.
Okay.
Now, before we get started, if you are interested in knowing the value of your home, please click on the home value search down below here. And if you are looking for a great property, you can click on the free home search and take a look at all the great homes for sale here in the area. Okay, so I'm so glad you're here, Michael, because so many of my clients, especially if you're going to purchase a house, you walk into the title company and you basically have the title company ask you, how do you want to hold title? Joint tenancy, community property, tenants in common. And a lot of times you go in and you actually didn't expect this conversation to happen and you have no idea what to check. So this video is designed for you. So Michael, tell us a little bit about what are the different ways to hold title and what are the pros and cons associated with each one?
Well, for single persons, usually holding title alone is a no-brainer because you're taking the title as separate property. And the exception is that if you're a married person and you take title solely in just the married person's name, under California law, that's still considered to be a community property acquisition. A lot of times if a married person wants to take title separately, they need to so designate on the title as their sole and separate property. And usually what the title companies will require that be done is either an interspousal deed or some type of quitclaim deed that will they will have the other spouse sign off on to make sure that separate property interest of a married person is valid as of record, both with the name and also with a sign off of the spouse. Okay. So that's an important starter.
Do you recommend that they contact you for that interspousal deed or for the agreement between the spouses?
Well, usually the title companies will provide that documentation. In other words, if you notify the title officer, the escrow officer, that you want to take title as separate property, they will probably routinely prepare a quitclaim deed. And so it's usually part of the package, the escrow package. So rather than spending money on me. But certainly, you know, if a client has questions, I get routine questions all the time. A lot of times they're little short questions I answer. I don't charge my clients for little quickies. So
yeah. Okay, great. Now, let's say that what is the joint tenancy or tenancy in common?
Well, if more than one person is taking title to property, then there are various forms of title. Probably one of the most common forms is joint tenancy. Another, I'll kind of review them first. Joint tenancies first, then tenancy in common is also a common form of title holding between multiple persons. Then another form would be community property, and we have a relatively new form of title in California, which is called community property with right of survivorship. Now the distinctions are this. If title is being taken as joint tenants between multiple persons, their interests in the property have to be equal interest. In other words, you can't have somebody owning 60% and the other person owning 40% between joint tenants. That would be more of a tenancy in common between multiple persons. The joint tenancy form of title a lot of times has been recommended by title companies when they don't have any other indication from a client. Probably that's the least desirable from married person's standpoint. And the distinction is this: if the property is in joint tenancy by right of survivorship, then on the death of one of the joint tenants, that title will pass to the survivor, and the documentation that's needed for that to clear the record title after the death of one joint tenant is to is to record an affidavit of death of the surviving joint tenant, so that they indicate, they attach a death certificate to that affidavit. It goes on record, and then that clears up the title. So it's a very simple way of avoiding probate. That's why a lot of times the title companies say, throw it into joint tenancy. So if you're a married person and you want to hold title with right of survivorship, there is this new form of community property with right of survivorship, where you pretty much do the same thing as a joint tenancy if you want to record a death certificate and show that the other person has passed away. And what occurs is the title in community property with right of survivorship means that it will automatically go to the survivor spouse upon death. So your will provisions or your trust provisions would not be applicable at all. So it's clearly just a survivorship tool. Tenancy in common is the other form of holding title that's common between non-related persons, or maybe related persons, parents and children and that sort of thing.
Yeah, sometimes we have two families buying a vacation home together.
Okay, yeah, that's a common one for up here, where children want to be part of the vacation home for the equity in the future.
Yes.
So they'll all kick in a little something to the down payment and then take title as tenants in common. Tenants in common means that each of those interests, and they can be unequal interests as tenants in common, but those interests then are divisible by your will, which means that if you're on title as tenants in common and you say in your will, I want it to go to someone who is not one of the tenants in common, then that can take place. A lot of times if we have tenants in common ownership on real property, sometimes the clients or your clients want to consider maybe some type of a tenancy in common agreement, so that it restricts ownership, so you don't end up owning the vacation home with an ex-wife or somebody else that you really don't desire to be on title.
Oh, that's really important. Great.
So another form of holding title is just simply in community property. That was typically the way we would recommend most people in California, most married persons in California, to hold title, because there's an important tax ramification to that. What occurs is upon the death of the first spouse, under an Internal Revenue Code section, there is an adjustment to basis of both halves of community property. This is an important concept, because if say you buy the real property at $500,000 and now it's worth several years later $1 million, and one of the spouses passes away, this adjustment to basis provision in the Internal Revenue Code allows a relief from capital gain. So what occurs then is if it's in community property, both halves of the basis gets a full adjustment to basis. We usually call that the step up in basis, because typically real property in California has appreciated. But we have had some downturn times, so it also works the other way. So you have to be aware of that, it also adjusts downward too. So if you bought the property for $1 million and then one of the spouse dies, and then the property is worth $800,000, then there is an adjustment downward on basis to $800,000. So you'll lose some of your basis. But those are important concepts. Okay. Probably we should talk about the popular alternative form now of holding title, which is through a trust.
Okay, great. Yeah.
Okay. Trusts come in a couple of varieties. One is a revocable living trust. The other is an irrevocable living trust. Living trust means basically it's between living persons. Testamentary trusts arise under a will, so you can have trusts in that mode also. But the popular mode is to create a revocable living trust between spouses. It's a joint trust, and then take title to the property in the joint trust, and that way you can avoid probate. You can have the character of the property be community property within the context of the trust. And what occurs then on the death of the first spouse, your successor trustees have the ability to pass the property where you designate.
Great.
Whether that be to the surviving spouse or children or other persons. So, so that's a very flexible way of holding title and to really having a sound estate plan.
Great.
Yeah.
Good. Well, Michael, thank you for all of that information. I hope that really helps. If you do have any questions, you can feel free to give me a call and I can give you Michael's contact information. Thank you so much for watching my video blog today.
Thank you, Christy, for having me.
Thank you for watching my video blog today. To receive the full video with detailed information on what we just discussed, feel free to get in touch with me or Michael and we can send you the full video with all the information.
Thank you, Christy.
You're welcome.
Okay.